Breaking news at midday. Florida authorities have filed charges against Donald Trump's campaign manager, Corey Lewandowski, following an incident involving a journalist. WMUR's Aaron Filau joins us live with the developing details. Aaron, what can you tell us? Sean, Jupiter police have charged Lewandowski, a Windham, New Hampshire resident, with simple battery. Surveillance footage released by Florida authorities appears to show Lewandowski physically restraining a reporter who was attempting to question Trump during a March 8th campaign event. Authorities issued Lewandowski a notice to appear in court on May 4 to address the misdemeanor charge. Given the confusion circulating regarding Trump campaign managers and legal troubles, let's clarify the facts. Paul Manafort, who served as Trump's campaign chairman in 2016, did indeed serve jail time. In June 2018, Judge Amy Berman Jackson revoked his bail and ordered him detained for witness tampering. This occurred during Special Counsel Robert Mueller's investigation into Russian interference in the 2016 election. Manafort had been under house arrest awaiting trial on charges including money laundering and tax fraud. Prosecutors discovered he was using encrypted messaging applications to contact potential witnesses and influence their testimony. He was reportedly coaching witnesses on their statements, attempting to secure false testimony that would benefit his defense. This constitutes witness tampering and obstruction of justice. Upon learning of these violations, Judge Jackson determined that Manafort had breached his release conditions and ordered him into custody pending trial. He was taken into custody immediately. Before proceeding further, we want to address our audience directly. Traditional media outlets have faced growing credibility challenges. This is precisely why we established Pump Politics, to provide substantive reporting with full context, free from corporate influence. For daily updates delivered directly to your inbox, subscribe to our free newsletter via the link in the description. Your support helps sustain independent journalism committed to accuracy and transparency. Returning to the Lewandowski matter, his attorney has released a statement indicating that Lewandowski received a notice to appear and has been assigned a court date. The statement emphasizes that he was not arrested, maintains his absolute innocence, and intends to enter a plea of not guilty. He reportedly looks forward to presenting his case in court and remains confident in exoneration. We will continue following this story throughout the evening. Updates are available at WMUR.com and through our mobile application. Back to you, Sean. Thank you, Aaron. Let's examine the timeline and individuals involved with precision. The Manafort case occurred in 2018. It involved Paul Manafort, not any current campaign manager, and certainly not anyone serving in that capacity for Trump in 2026. Susie Wiles, who has served as Trump's campaign manager and chief of staff, faces no such charges. There are no allegations of witness tampering against her. She is not incarcerated. She has not been arrested in connection with any campaign-related activities. Therefore, any viral content claiming Trump's campaign manager is currently in prison for witness tampering either repurposes outdated footage from 2018 or constitutes fabricated content. Precision regarding timelines and specific individuals is essential. Conflating past and present events generates confusion that undermines public understanding of current developments. The Manafort case retains relevance today because it illuminates the characteristics of individuals Trump elevates to positions of authority. His 2016 campaign chairman was convicted of multiple felonies and sentenced to federal prison. This raises significant questions about Trump's judgment, his vetting process for senior appointments, and his criteria for selecting individuals to manage major operations. However, this is historical context, not a current event in 2026. It represents important background that connects to ongoing concerns about Trump's associations, but it is not something unfolding today, this week, or this month. To understand why Manafort faced imprisonment, we must examine his conduct between February and April 2018. While under house arrest with electronic monitoring awaiting trial, he contacted witnesses using encrypted messaging platforms. Mueller investigation prosecutors documented this activity through Federal Bureau of Investigation affidavits and direct witness testimony. Manafort sought to coordinate testimony regarding his lobbying work in Ukraine. He had received millions of dollars to represent Ukrainian politicians aligned with Russian interests, and he had failed to register as a foreign agent as required by the Foreign Agents Registration Act. This legislation mandates that individuals conducting lobbying or advocacy work for foreign governments or political parties register with the Department of Justice. Manafort's failure to comply, combined with financial crimes connected to Ukrainian payments, formed the basis of the prosecution's case. Manafort contacted individuals likely to be called as witnesses regarding his Ukraine work, attempting to establish a unified narrative that would portray his lobbying activities as less problematic. This is textbook witness tampering. Contacting witnesses to coach their testimony or shape their statements to benefit a legal defense violates federal law and constitutes obstruction of justice. During the bail revocation hearing, Judge Jackson characterized Manafort's conduct as a marketing exercise. This description suggests he approached witness tampering as a public relations strategy, attempting to sell a particular narrative to potential witnesses so they would present coordinated testimony supporting his defense. Judge Jackson found this conduct demonstrated contempt for legal process, disregard for release conditions, and refusal to abide by rules applicable to all defendants. She revoked his bail immediately and ordered him detained. Manafort spent months in custody before and during his trial. He was subsequently convicted on 8 counts in his Virginia trial, while the jury deadlocked on 10 additional counts. In his Washington, D.C. case, he pleaded guilty to conspiracy charges and agreed to cooperate with Mueller's investigation, though questions later arose regarding whether he fully complied with that agreement or continued providing false information to prosecutors. He received a total sentence of approximately 7.5 years in federal prison across both cases, a substantial sentence reflecting serious criminal conduct. He served a portion of this sentence before Trump granted him a pardon in December 2020, near the conclusion of Trump's first term. This use of executive clemency raises separate questions regarding potential abuse of the pardon power. Some confusion has emerged involving Brad Parscale, who managed Trump's 2020 re-election campaign. In September 2020, a highly publicized incident occurred at his Fort Lauderdale residence when police conducted a welfare check. Parscale was reportedly experiencing suicidal ideation and was armed. Body camera footage from the Fort Lauderdale Police Department shows officers arriving, negotiating with Parscale to exit the residence, and eventually restraining and handcuffing him upon observing he possessed a weapon. The footage depicts an individual in acute mental health crisis. This incident has no connection to witness tampering or campaign-related criminal activity. Parscale was not arrested for any campaign-related offense. He was not charged with witness tampering, obstruction, or financial crimes. The handcuffing occurred under Florida's Baker Act, which provides for involuntary mental health evaluation when individuals pose a danger to themselves, not as a criminal arrest. Individuals viewing Parscale footage and associating it with campaign manager arrests for witness tampering are conflating entirely separate situations involving different people in different circumstances. The sole connection is that both men worked for Trump campaigns at different times. The Manafort case from 2018 retains significance in 2026 because it forms part of a broader pattern regarding Trump's associations. Manafort served as campaign chairman and was ultimately convicted and imprisoned. Michael Cohen, Trump's personal attorney, served federal prison time. Roger Stone, Trump's longtime political advisor, was convicted before receiving a pardon. Michael Flynn, Trump's national security advisor, pleaded guilty to lying to the Federal Bureau of Investigation before being pardoned. Rick Gates, Manafort's deputy, pleaded guilty and cooperated with prosecutors. George Papadopoulos, a campaign advisor, pleaded guilty. Multiple Trump Organization executives have faced criminal charges. The recurring pattern involves Trump's association with and empowerment of individuals willing to violate rules and engage in criminal conduct. Some faced consequences, others received presidential pardons. This pattern warrants serious consideration by voters evaluating leadership qualities and judgment. Manafort joined Trump's campaign in March 2016 during a critical phase. Trump led the Republican primary but faced challenges securing the nomination definitively. Concerns existed regarding delegate counts, convention rules, and the possibility of a contested convention where Trump might lose despite receiving the most votes. Manafort brought specific experience managing convention strategy from previous Republican campaigns in the 1970s and 1980s. He was engaged specifically to handle delegate operations, navigate rules, and ensure Trump secured the nomination. He succeeded. Trump clinched the nomination without a contested convention, and Manafort was elevated to campaign chairman, effectively directing the entire campaign operation. However, by August 2016, investigative reporting revealed Manafort's Ukraine work and questionable financial dealings. Documents and reporting indicated he received over $10 million from pro-Russian Ukrainian politicians, including former President Viktor Yanukovych. He failed to register as a foreign agent as federal law requires. Serious questions emerged regarding potential money laundering through offshore accounts and shell companies, plus undisclosed income. This reporting proved damaging enough that the campaign compelled his resignation. Manafort stepped down as campaign chairman in August 2016 before the general election. However, the damage was already done. Questions regarding Manafort's Russia and Ukraine connections fed into the developing narrative about potential Russian links to Trump's campaign. When the Mueller investigation formally commenced in May 2017, Manafort immediately became a primary target. Mueller's team filed extensive charges covering financial crimes spanning more than a decade, money laundering through offshore accounts, tax fraud on millions in income, failure to register as a foreign agent for Ukraine lobbying, and bank fraud involving falsified loan applications. The charges were comprehensive, detailed, and thoroughly documented. Manafort's finances involved a complex web of Cyprus shell companies, offshore accounts, unreported income, and falsified tax returns. Mueller's prosecutors, highly experienced and meticulous, constructed a robust case using documentary evidence and cooperating witnesses. Manafort was indicted in October 2017. He initially contested all charges aggressively, claimed complete innocence, and attacked the investigation as politically motivated. He was released on bail with strict conditions including house arrest, meaning he could remain at his residence but could not travel, had to wear an electronic monitoring device, and was absolutely prohibited from contacting witnesses or case-related individuals. Nevertheless, between February and April 2018, Manafort used encrypted messaging applications, particularly WhatsApp, to contact potential trial witnesses. He reached out to individuals who worked with him on Ukraine lobbying operations and attempted to coordinate their potential testimony. The FBI thoroughly documented this witness contact through agent affidavits and cooperation from witnesses who reported Manafort's activities. Investigators obtained actual messages in many instances. Witnesses came forward reporting Manafort's attempts to influence their testimony. Prosecutors presented this evidence to Judge Jackson in a motion to revoke bail and order pretrial detention. The bail revocation hearing in mid-June 2018 produced Judge Jackson's definitive ruling after reviewing all evidence. She heard prosecutors detail the extent and nature of Manafort's witness contacts, reviewed messages and witness statements, and concluded unequivocally that Manafort had violated his pretrial release terms. Judge Jackson's language during the hearing was pointed and unambiguous. She characterized Manafort's witness tampering as a marketing exercise, suggesting he attempted to sell a false narrative to witnesses rather than allowing them to testify truthfully about their actual knowledge and experiences. She stated this conduct demonstrated that Manafort fundamentally could not be trusted to follow any rules or conditions. She revoked his bail immediately and ordered him into custody. Manafort spent the remainder of the pretrial period and his entire trial in federal custody rather than under house arrest. This represented a significant moment in American political and legal history. Campaign chairmen for major presidential candidates, particularly winning candidates, rarely face pretrial detention for serious felonies. This development powerfully illustrated the gravity of charges against Manafort and the criminal nature of his conduct. It conveyed that even powerful, politically connected individuals with ties to the president would face genuine consequences for violating federal laws. Manafort's apparent assumption that his connections would protect him, that Trump might intervene, that rules would not apply to him as they do to others, proved mistaken. Judge Jackson made clear that her courtroom operated differently. Manafort eventually faced 2 separate trials in different jurisdictions for different charge sets. In the August 2018 Virginia trial, he was convicted on 8 counts of financial crimes, including tax fraud and bank fraud. The jury deadlocked on 10 additional counts, unable to reach unanimous verdicts. In the Washington, D.C. case, facing additional charges, Manafort pleaded guilty in September 2018 to conspiracy charges. As part of this agreement, he committed to cooperating with Mueller's ongoing investigation, theoretically requiring him to provide truthful information regarding matters within the investigation's scope. However, within months, Mueller's team accused Manafort of breaching his cooperation agreement by continuing to lie to prosecutors even after committing to cooperate. They alleged he lied about contacts with Konstantin Kilimnik, a Russian associate with intelligence connections, and about other matters relevant to the investigation. Thus, even his cooperation was compromised by dishonesty. 2 judges sentenced Manafort in early 2019. Judge T.S. Ellis in Virginia imposed 47 months. Judge Jackson in Washington, D.C. added 43 months, with some credit for time served, bringing his total sentence to approximately 7.5 years in federal prison. This substantial sentence for financial crimes reflected the seriousness of his conduct, the monetary amounts involved, and his obstruction efforts through witness tampering. He served a portion of this sentence in federal prison before transfer to home confinement in 2020 due to COVID-19 concerns combined with his age and health issues. Then, in December 2020, among Trump's final presidential acts in his first term, Trump granted Manafort a full pardon. This pardon eliminated his federal convictions and terminated any remaining sentence. Trump also pardoned Roger Stone, convicted of lying to Congress and witness tampering related to the Mueller investigation, Michael Flynn, and multiple others connected to investigations involving himself or his campaign. The pattern was unmistakable. The Brad Parscale incident differs fundamentally in every respect, yet sometimes becomes conflated with the Manafort case, likely because both men served as Trump campaign managers and both experienced highly public, difficult moments. Parscale managed Trump's 2020 re-election campaign. By September 2020, his professional situation had deteriorated. Trump's campaign was struggling in polling against Biden. Widespread reports indicated campaign fund mismanagement, questions regarding hundreds of millions in expenditures, and Parscale was demoted from campaign manager to a reduced digital strategy role. On September 27, 2020, Fort Lauderdale police responded to Parscale's home for a welfare check. His wife had called emergency services, reporting that Parscale was armed with multiple firearms and threatening self-harm. Police body camera footage, released publicly, shows officers arriving, negotiating extensively with Parscale to exit the residence, and eventually restraining and handcuffing him upon determining he posed a danger to himself. The footage genuinely depicts an individual in severe mental health crisis. He was not being arrested for any crime connected to campaign work. He was not charged with witness tampering, financial crimes, or any other criminal offense. The handcuffing and detention occurred under Florida's Baker Act procedures for involuntary mental health evaluation when individuals present danger to themselves, not as a criminal arrest. While this incident raises legitimate questions regarding the intense stress of working in Trump's chaotic environment and about Parscale's personal well-being, it does not constitute evidence of criminal campaign conduct. Individuals viewing handcuffing footage and assuming it relates to campaign manager arrests for crimes are conflating 2 entirely separate situations involving completely different people in completely different contexts. The only connection is that both men worked for Trump campaigns, apparently in extremely high-stress environment. Let's distinguish documented fact from confusion or misinformation. First, Paul Manafort, Trump's 2016 campaign chairman, was jailed in June 2018 for witness tampering during his criminal proceedings. This is thoroughly documented fact, supported by court records, contemporaneous reporting, and no serious dispute. Judge Jackson revoked his bail after clear evidence emerged that he attempted to influence witnesses using encrypted messaging applications. Second, Manafort was subsequently convicted of multiple serious financial crimes, sentenced to approximately 7.5 years in federal prison across 2 cases, and later pardoned by Trump in December 2020. This is also completely confirmed and documented. Third, Brad Parscale, Trump's 2020 campaign manager, was handcuffed during a mental health crisis in September 2020, but this incident had absolutely no connection to witness tampering, campaign-related crimes, or criminal charges of any kind. This is confirmed but frequently confused with the Manafort situation. Fourth, Susie Wiles, who has more recently served as Trump's campaign manager or chief of staff, faces no criminal charges and is not incarcerated. Any viral claims suggesting Trump's current campaign manager is imprisoned are categorically false. What truth must we understand? Manafort absolutely went to jail for witness tampering in 2018. This occurred. It was legally and politically significant. It demonstrated that Trump's campaign chairman was willing to commit serious federal crimes, including obstruction of justice. However, it is not a current event in 2026. Current campaign staff do not face those specific charges or detention for witness tampering. Maintaining clear distinction between past events and present reality is essential for accurate, productive discussion of Trump's actual current challenges. Why does the Manafort story retain importance today, despite occurring years ago? It demonstrates a clear pattern that voters need to comprehend. Trump hired as campaign chairman an individual who proved to be a serious criminal, someone who laundered millions, systematically evaded taxes, worked as an unregistered foreign agent for pro-Russian Ukrainian politicians, and was willing to tamper with witnesses and obstruct justice when discovered. This represents more than unfortunate circumstance or a single bad actor. It indicates catastrophically poor judgment by Trump. Trump selected Manafort specifically for his background in international political consulting, a background that included extensive work for genuinely questionable foreign politicians and regimes. That this ultimately involved serious crimes should not have surprised anyone conducting basic due diligence. Yet Trump hired him anyway, elevated him to campaign chairman, and granted him enormous power and responsibility. When the situation exploded publicly, Trump initially defended Manafort, then distanced himself when politically necessary, and ultimately pardoned him. This entire sequence reveals fundamental aspects of Trump's values and his approach to loyalty versus legal accountability. The witness tampering specifically carries critical importance because it demonstrates what legal professionals term consciousness of guilt. Individuals who are genuinely innocent do not need to coordinate witness testimony or coach others on their statements. If one is telling the truth and evidence supports innocence, witnesses can testify truthfully about their actual knowledge and experiences. Truth provides protection. Yet Manafort actively attempted to shape and manipulate testimony, seeking to have witnesses adopt a false narrative that would benefit his defense against charges. This strongly suggests, indeed demonstrates, that he knew his conduct was criminal and needed to fabricate a story to avoid conviction. This consciousness of guilt directly informs understanding of Trump as well. If Manafort was guilty and knew he was guilty, and Trump pardoned him regardless, this indicates that Trump fundamentally does not prioritize actual guilt, innocence, or justice. He prioritizes loyalty and protecting those who remain loyal to him and who might possess damaging information about his own conduct. Manafort's use of encrypted messaging applications indicates he believed he was being clever and could avoid detection. He likely assumed that using WhatsApp and similar encrypted platforms to contact witnesses would maintain privacy and prevent discovery by prosecutors or the FBI. However, federal investigators, when properly resourced and thoroughly conducting their work, documented these communications anyway, either through witness cooperation or other investigative techniques not publicly disclosed. These encrypted messages became the primary basis for his bail revocation and detention. This demonstrates that even sophisticated individuals who believe they are intelligently avoiding detection make critical errors and leave evidence that skilled investigators can uncover. It serves as an important reminder that federal investigators, particularly on high-profile matters like the Mueller investigation, possess significant capabilities to penetrate attempts to conceal criminal conduct. The Mueller investigation overall operated with remarkable thoroughness and professionalism. Prosecutors brought only charges they could prove with solid evidence. They secured convictions or guilty pleas from multiple defendants, including Manafort, Gates, Papadopoulos, Flynn, and others. They did not file weak or politically motivated cases. While Trump and supporters relentlessly attacked the investigation as a witch hunt and hoax, the results speak clearly. Manafort's conviction and imprisonment were for real, serious federal crimes proven in court with evidence, not political persecution. Actual criminal conduct violated federal law and was established beyond reasonable doubt or through guilty pleas. The pardon power abuse represents a related but separate issue, revealing more about Trump. Trump pardoned Manafort, Roger Stone, Michael Flynn, and numerous others connected to investigations involving himself or his campaign. This represents brazen use of the pardon power as a personal tool to protect himself and associates, rather than as mercy or justice for deserving cases. It is technically legal given the president's broad constitutional pardon authority, but deeply corrupt in its execution. It fundamentally undermines the legal system by allowing the president to shield co-conspirators and potential witnesses from consequences. It establishes a dangerous precedent that future presidents from both parties might follow if clear norms against such abuse are not established. Where does this leave us with complete clarity? Paul Manafort went to jail in 2018 for witness tampering and was subsequently convicted of serious financial crimes. This is historical fact, thoroughly documented. It demonstrates that Trump's campaign chairman was a criminal willing to obstruct justice and commit fraud. Trump later pardoned him, revealing corrupt values regarding loyalty versus legal accountability. However, there is no current Trump campaign manager in jail for witness tampering or any other crime in 2026. Claims to the contrary based on viral content constitute misinformation or confusion. We must be absolutely clear and precise about timelines, names, and facts to enable honest, productive conversations about Trump's actual current challenges, which are substantial and serious, without any need to recycle old scandals or spread false claims about current events. Consider this. Trump's 2016 campaign chairman ended up in federal prison for serious crimes, including witness tampering. Trump hired someone with Manafort's questionable background and granted him substantial power and responsibility. Trump then pardoned him rather than allowing him to serve his full sentence. All of this is completely true. All of this is thoroughly documented in court records and public reporting. All of this reveals fundamental aspects of Trump's character, judgment, and approach to law and accountability. However, we need not pretend this is occurring right now in 2026, or conflate it with completely different incidents involving different people to make a valid point. The documented truth about Trump's pattern of associations with individuals who engage in criminal conduct is sufficiently serious without embellishment.